Comrade Hope is the contact person at the moment.
Good morning, Honorable Tambo.
Good morning.
Yeah, it's bad, Baba. I'm so shocked about Comrade Jake.
Kathy, how's things in Cape Town with the mountain?
I'm not in Cape Town, I'm in Gauteng. I'm in Gauteng, Comrade.
Comrade Mogai. Okay.
Demand. Bambolonye.
I was mina ngempela ke we. Kathi ke manje na ngithola umuntu ongazi.
Yebo.
Ninjani putwami?
Yaphile.
Hayi siyaphila njena hayi. Siphila ngengcacamezela.
Yeah. Nsi.
Hayi kubi kunzima. Ya ngathi uyasigijimisa futhi lo lukhokhovu lo.
Hey, lo nyaka uphelile nalo.
Hayi kunzima putwami.
Ngathi relay omunye unikeza omunye unyaka relay.
Good morning, veteran.
Hey,
good morning.
Veteran survivor of the COVID wars.
Good morning.
We celebrate you.
Good morning, Nopala.
Good morning, honorable members. I just want to confirm that we have Honorable Mudisa.
Yes, Honorable Mudisa is in the platform.
Thank you very much. Do we have Honorable Shank?
Yes, on the platform.
Okay, thank you very much. I am not sure, honorable members, if there's going to be any declarations insofar as the two bills are concerned. And if declarations, do we have the members who are going to make declarations?
I'm here, Advocate. Good morning.
Okay, thank you very much. Any other member who's going to make a declaration?
Yes, Adinwe Pepe, I'm present, Honorable.
Thank you very much. Any other member who's going to make a declaration?
Yes, Advocate, we have Mutama who's going to do the declaration on behalf of the year. Yeah,
I'm here.
Okay, thank you, Honorable Mutsamai. Any other member?
Honorable Matibe.
Honorable Matibe. Okay, any other member?
Honorable Labiskachni.
Honorable Labiskachni, thank you very much. Any other member? Okay, thank you very much, honorable members. Do we have the chief whip?
I'm in order. I've been here waiting for you.
Thank you very much, chief whip. Honorable members, I just wish to also remind members about the interpretation. The interpretation is available. Please make sure that you activate the interpretation so that you can have access to interpretation if a need arises. Thank you very much, honorable members. Chairperson, we still have 2 minutes towards the time. We do have a quorum. Chairperson.
No, thank you very much, honorable members. In keeping with the NCOP tradition, I'll bow to my right and bow to my left. And having done so, I'll request delegates to observe a moment of silence for prayer and meditation. Thank you very much. Let me then take this opportunity to please remind members that the rules and processes apply. I would like to remind you of the following. That the virtual sitting constitutes a sitting of the National Council of Provinces, that the place of sitting is deemed to be Cape Town, where the seat of the National Council of Provinces is. Delegates in the virtual sitting enjoy the same powers and privileges that apply in a sitting of the National Council of Provinces. For purpose of the quorum, all delegates who are logged onto the virtual platform are deemed to be present. Delegates must always switch on their videos, and delegates should ensure that the microphones on their gadgets are muted and must always remain muted. The interpretation facility is active, as has already been indicated, and any delegate who wishes to speak must use the raise your hand function. And by now, honorable members are familiar with this function. I'm told that there'll be no notices of motions or motions without notice. And that being the case, we will then proceed to the order paper. Honorable delegates, we shall now proceed to the first order. Consideration of upgrading of land tenure rights amendment bill, B6B-2020, National Assembly.
Chair, on a point of order.
Yes. Honorable Labuschagne, what's the point of order? Honorable Labuschagne?
I think she's been dropped, Chair.
Yeah, but can we try and get her back back to the system so that we can attend to the issue that she's trying to raise? Labuschagne, is it Boshoff or Labuschagne?
No, Chair, it's Labuschagne. I just said when you were calling her name, it seems as if she's been dropped.
Okay. But honorable members, can we please proceed whilst the problem is being raised? I was saying that we shall now proceed to the first order, consideration of upgrading of land tenure rights amendment bill, B6B-2020, National Assembly Section 76, and report of Select Committee on Land Reform, Environment, Mineral Resources, and Energy thereon. I now call on Honorable T.C. Mudise, Chairperson of the Select Committee, to present the committee report. Honorable Mudise.
Thank you very much, Honorable Chairperson, Honorable Deputy Chairperson, Honorable Minister and Deputy Minister, Honorable members of the NCOP provincial delegates, ladies and gentlemen. Honorable Chairperson, allow me to present the report of the Select Committee on Land Reform and Rural. Honorable Chairperson, on the 16th of February, after the National Assembly referred the upgraded Land Right Tenure Amendment Act to the committee on the 1st of December 2020, the Bill B12B 2017, the Department of Agriculture and Rural Reform came to brief the committee in that meeting where the Select Committee invited all the provincial legislature to the meeting. The bill amendment Bill B6B of 2020 focused on the two important implementing court decisions. The court ruling regarding the upgrading of the Land Tenure Act. In the first ruling, the court set aside Section 2, subsection 1 of the Act, which was found unconstitutionally as excluded women from the property system. This amounted the gender discrimination in contravening of the section 9 of the Constitution. That Rahube, Vice Versa Rahube, take this matter to court, and court agreed to. And Parliament was required to introduce constitutionally sound procedure for the determination of the right of ownership and occupation of the land remedy. In the second ruling, the court confirmed that Section 25A of Ultra is invalid to the extent that it is not cover all the applications, not cover all the Republic of South Africa, particularly in the homeland. The amendment of Section 25 of the Ultra partially addressed the court ruling, and in this second court ruling, there was no court deadline like the first one. The Parliament was given until the 29th of April 2021. Honorable Chairperson, after all these things, the public participation was held. On the 17th of February, the Select Committee again sent all the Select Committee advertised a call for public comments on the bill. Media platform were used in the broader sector of our country. As you know, in 1995, the Freedom Charter declared that, close quote, open quote, people shall govern, close quote. And indeed, parliamentary public participation is one of the mechanisms that ensure that the voices of our people heard in legislative and policy making. That's why all the provinces held their public hearing and make sure that all the people in the province participate in this amendment bill because it was a very difficult bill and it was a bill that was oppressing a Black women. Honorable Chairperson, when I was saying that the committee, when they received the public, the comments from the provinces, we received the comment from the Royal Bafokeng, Northwest, Banking of South Africa Association, Social Justice Coalition, Justice Coalition, Corruption Watch, and COSATU, and others. They were commenting that this act of 1991, the bills was an apartheid era and did not consider or not regard the view of the Black African majority, and they needed it to be amended. On the 7th of April, the Select Committee held its negotiating mandate, where 7 provinces sent their 6 provinces sent their negotiating mandate, and 6 provinces supporting the bill. 1 province was not supporting, and 2 provinces did not send their mandate. When
if I can ask you, Honorable Mdisa, to steady your movement, otherwise the camera is capturing you, moving in 101 directions and so on. So
okay,
please proceed.
The 6 provinces were supporting the bill, and 1 province did not support the bill, and 2 provinces did not send their mandate, whereas the other one requested the chairperson of NCOP to give them extension to make sure that they cover the vast province, to reach everybody, to make sure that everybody is reached. And 1 province, which was briefed, didn't hold its public hearing. Honorable Chairperson, on the 13th of April, the committee held its meeting on the final mandate. The committee received 8 mandates from the provinces. 1 did not submit, whereas 7 provinces support the mandate, the bill, and 1 province did not support the mandate. The act. We do not take this, as the Select Committee, we do not take as for granted the impact, the importance of the land in helping improving the economic condition of many vulnerable women of our country, in recognizing the importance that the land plays in an economy. In his 2019 SONA, His Excellency President Honorable Ramaphosa said, I quote, "Faster economic growth require accelerating land reform in rural and urban area and a clear property rights regime," close quote. Honorable Chairperson, in my conclusion, the Select Committee on Land Reform, Environment, Mineral Resource and Energy, having deliberated and considered the subject of upgrading of the Land Tenure Amendment Bill B6B 2020, National Assembly Section 76, refer to it as classified by JTMS Section 76 bill. The committee agreed on it. whereas one province did not. And the committee noted that because this province, they opted to remain in Egypt, where women were nothing, where women were oppressed. And again, the committee noted that their province, it was not an easy for them to change.
Chairperson,
To change their...
Chairperson, on a point of order.
Yes, a point of order, Labuschagne.
I think the chairperson is reading something in the report that the committee never agreed upon. The part that said that that is a province where women are oppressed, that was not discussed, and it's not a true reflection of what was going on in the committee. I strongly oppose against something of a personal opinion that the chairperson put into a report. Thank you.
Honorable Labuschagne, that's not a point of order.
Thank you very
Can
much,
I
Honorable
ask
Chairperson.
Honorable Mudisa to conclude?
Thank you very much, Honorable Chairperson. And then we noted that if they don't want to, they want to remain in Egypt, it's fine for them to remain in Egypt, where women is nothing, where women were oppressed. Thank you very much, Honorable Chairperson. The bill was agreed by the committee. Thank you very much.
Thank you very much, Honorable Mudisa. That concludes the debate. But before I continue, let me just note that it has been brought to my attention that the minister and deputy minister have joined us. So we take this opportunity to welcome both the minister and the deputy minister to this sitting of the NCOP. I shall now put the question. The question is that the bill be agreed to. But before we continue, we shall now proceed to to look at the whole question of declaration and ask provinces to indicate whether they intend making declarations in terms of Rule 71. If they so wish, the maximum time for the declaration is 3 minutes per province. Any declarations?
Yes, Chair.
Please proceed.
Can I proceed, Chair?
Please proceed.
Honourable Chairperson, the Western Cape cannot support the amendment bill as it may fall short of Section 1542 of the Constitution due to a lack of public consultation for which it was referred to in the first place. Secondly, the amendment bill only addresses sections of the Act whereas the entire Act should have been repealed and an entirely new bill be introduced. This bill is in its current state sustains apartheid legislation that discriminates against South Africans that stay in tribal and communal areas by preventing them from owning property like the rest of South Africa. This is a disgrace, and every province that supports this bill, as it stands today, should hang their heads in shame for sustaining separation laws that translates in Afrikaans to apartheid. Thirdly, this bill does not provide for the ordinary South African who will not be able to afford legal fees to apply to court for appropriate relief, as only a few determined elite people will be able to stand up for themselves. Lastly, it was clear in the Select Committee proceedings during the negotiating mandate phase that the majority of the provinces were not happy with the bill as it stands, but delegates were quickly railed in by the ANC to toe the line, and the chairperson allowed that. This caused great confusion and chaos as provincial delegates first supported an amendment, but quickly changed their vote after a so-called 5-minute caucus with the Secretary of the Parliament, which was then called as caucuses with their provinces. Therefore, the Western Cape cannot support the bill.
Thank you very much. Any other province wishing to make a declaration?
My hand is up, Mpumalanga, Chair.
Mpumalanga, please proceed.
Thank you, Honorable Chairperson of the House. Minister and Deputy Minister, honorable members, provincial delegates, fellow South Africans, good morning. House Chairperson, we are happy as the African National Congress that the Department of Agriculture, Land Reform and Rural Development has responded positively to the order of the Constitutional Court in response of the two cases that have been mentioned here today by my colleagues, the chairperson. The ANC's land reform policy has got three pillars, and that is land redistribution, restitution, and security of tenure. The department has in the past briefed this select committee on progress and further plans to ensure that the land tenure security is strengthened in our country. We have taken note of the concerns that have been raised by members of the public, and as the ANC, we are happy that the department will, in this financial year, introduce communal land tenure legislation that will deal broadly with matters of tenure security in the communal or former homeland areas. Given the initiative chairperson undertaken by the department, we are content with the conclusion of the application of section 19 and 20 of the 1991 Act, as the court had only confined itself to section 3 of the same Act. Chairperson, we support the proposed amendment that the executive must be able to receive, adjudicate, and resolve any dispute related to an application for conversion of land rights into full ownership. In conclusion, Chair, in order to appreciate the progress that has been made in terms of our land reform program, it is important that we read ULTRA in conjunction with other relevant pieces of legislation. We will concern ourselves much with the DA as it is within their blue blood to reject transformative legislation that seeks to redress the historical injustices. The call by the EFF that the department should review the land reform legislation did not assist with process, and we hope that they will wake up to realize the complexities of apartheid era law. Thank you very much, Chairperson and the House.
Thank you very much. The next person to speak is Honorable Bibi from KwaZulu-Natal. Honorable Bibi.
Okay, thank you very much, Honorable Chairperson. Greetings to Honorable Chairperson of the House, Ministers and Deputy Ministers present, Honorable Members of the NCOP, Provincial Delegates, and ladies and gentlemen. Honorable Chairperson, the discrimination of women remains of the triple challenges of race, class, and gender that the African National Congress is working towards its eradication. In the month of freedom, we are reminded of the sterling job that women in South Africa played in helping realize the goal of the Freedom Charter, that people shall govern. During apartheid, Black people were not recognized as citizens of South Africa by government and could therefore not be able to own any land or property. The apartheid government not only made laws that are radically discriminatory, but they furthermore enacted pieces of legislation that perpetuated the oppression of women on the basis of their gender, and thus effectively reinforcing a very patriarchally political and socio-economic. Ultra 1991, Upgrading of Land Tenure Rights Act, is one such piece of legislation, vestige of an oppressive system of colonialism apartheid that was passed in 1991 and sought to provide for the upgrading of conversion into ownership of the tribes. Women were excluded in terms of this 1991 legislation from owning any land and property, which was very bad, Chairperson. the Ultra Amendment Bill, the bill was necessitated by the two constitutional court cases. That is, firstly, Rahube versus Rahube, and secondly, in the Herbert Noah and other versus Sengu municipality. In the Rahube case, Section 2 of Ultra was found to be unconstitutional insofar as it discriminated against the rights of women to independently own property and did not afford interested persons an opportunity to object to the conversation. In the same matter, it was found that Section 25A of Ultra Act, which excluded the application of Section 3, same act in the former Transkei, Bophuthatswana, Venda, and Ciskei states to be unconstitutional. The ANC supports the bill as it will ensure women access and ownership of land and property, and this will have a positive impact in terms of ensuring that justice of the past are corrected and further boost the skewed land property ownership by women. I thank you, Chairperson.
Thank you very much.
Well done, Honorable Bibi. Well done. Thank you.
Thanks.
Any other declaration from any other province?
Thank you very much, Chairperson. Limpopo.
Please proceed.
Thank you very much, Chairperson, and greetings to the Minister and Deputy Minister, provincial delegates. There can be no doubt, Chairperson, that the ANC has made progressive strides in terms of ensuring that the legacy of apartheid is fully eradicated. This parliament has since 1994 passed legislation that positively seeks to empower women in our country. However, the face of poverty in South Africa still remains Black, African, and its gender is female. Therefore, I stand on behalf of Limpopo to declare that the ANC supports the Ultra Amendment Bill, and this piece of legislation will ensure that it is not only respond to the order issued by the highest court in the land, but it contributes towards the transformation of ownership patterns of land and property in this country. The Ultra Bill proposed amendments are consistent with what we would like to achieve as the ANC as far as the empowerment of women is concerned. The amendment bill will not automatically convert into ownership in terms of Section 2, the deed of grant or permission to occupy, without first making it publicly known. The Department of Agriculture, Land Reform and Rural Development will invite the public to object to an application for a conversion of deeds of grants or PTO by any interested person, and the bill make provision for mediation and dispute resolution. There can be no doubt that the impact of this proposed legislation can only be positive, and this is not only the piece of legislation under the department, as there are other pieces of legislation and policies that are aimed at enhancing women's ownership of land and property. In conclusion, Chairperson, the women in South Africa remain vulnerable and have suffered all sorts of physical and emotional abuse. And this, in redressing this persistent challenge, the House will continue to pass legislation that will transform our society and ensure that the achievement of gender equality in our democratic nation. And therefore, Limpopo supports the bill. Thank you very much.
Thank you very much. Any other province wishing to make a declaration? None? We'll now proceed to voting on the question. And the question is that the bill be agreed to. And when called upon to do so, heads of delegations must indicate whether they vote in favor, against, or abstain. We will do so, do the voting in an alphabetical order. We'll start with the Eastern Cape. Eastern Cape?
Agreed. Agreed, Eastern Cape.
Eastern
Agreed.
Cape in favor. Free State?
Free State votes in favor, Honorable Chairperson of the Council.
State votes in favor. Gauteng?
Gauteng votes in favor, Chairperson.
Gauteng votes in favor. KwaZulu-Natal?
iKwaZulu Natal iyayeseka Sihlangu umbili.
KwaZulu-Natal seka. Limpopo?
Limpopo supports.
Limpopo is voting in favor. Mpumalanga?
Mpumalanga supports. In favor.
Mpumalanga supports. Northern Cape?
Northern Cape supports.
Northern Cape supports.
Northern Cape supports. Northwest does not have a mandate. No mandate from Northwest. Western Cape?
Western Cape does not support.
Western Cape is against. Does not support. So the seventh, now that voting is closed, 7 provinces have voted in favor. I therefore declare the bill agreed to in terms of Section 65 of the Constitution. Thank you very much. We'll move to the next order. So, honorable delegates, we shall now proceed to the second order, consideration of Correctional Services Amendment Bill B32-2020, National Assembly Section 75, and report on Select Committee on Security and Justice thereon. So I call on Honorable S. Shaik, Chairperson of the Select Committee, to present the committee report. Honorable Shaik.
Thank you, Honorable Chairperson, and good morning, honorable members. Honorable Chairperson, the Correctional Services Amendment Bill B32-2020 was referred to the Select Committee on Security and Justice on the 9th of March 2021. The committee has agreed to the bill without proposed amendments. Honorable Chairperson, the bill was developed to give effect to the Constitutional Court judgment known as the Pathla judgment. The Constitutional Court, in its judgment dated the 3rd of May 2019, in Opa Chipani Pathla versus the Minister of Justice and Correctional Services and another, found certain sections of the Principal Act to be unconstitutional and ordered the amendment of those sections by Parliament within a period of 24 months from the date of the order, that is before the 3rd of May 2021. The Constitutional Court varied and confirmed an order of invalidity of the High Court of sections 136 subsection 1 and 73 subsection 6b4 of the Principal Act, in that these sections were declared inconsistent with sections 9 subsection 1 and 3, as well as section 35 subsection 3n of the Constitution of the Republic of South Africa. Honorable Chair, Mr. Pathla, an inmate serving a sentence of life imprisonment, was convicted on the 25th of September 2004 for offenses committed earlier, but was sentenced only on the 5th of October 2004. This meant that, in line with section 136 subsection 1, read together with section 73 subsection 6b4 of the Principal Act, he was required to serve 25 years before he could become eligible to be considered for parole placement. If he had been sentenced before the coming into operation of Chapter 7 of the Principal Act on the 1st of October 2004, he would have had to serve only 20 years before being eligible for consideration for parole placement. He challenged Section 136(1) of the Principal Act in the High Court on the grounds that the use of the date of sentence rather than the date of commission of offense violated his right to a fair trial as contemplated in section 35, subsection 3 end of the Constitution. He also contended that section 136, subsection 1 breaches his right to equal protection of the law and the right not to be unfairly discriminated against in terms of section 9 of the Constitution. The Constitutional Court held that the impugned provisions breach the constitutional rights to equal treatment by the law and not to be discriminated against unfairly. The court also found that the impugned provisions amounted to retroactive application of the law, which violated the principle of legality. Section 136, subsection 1 of the Principal Act is a transitional provision, and the Constitutional Court ordered that this section shall read as follows, pending the amendment thereto by Parliament within the period ordered. Any person serving a sentence of incarceration for an offence committed before the commencement of chapters 4, 6, and 7 of the Correctional Services Act is subject to the provisions of the Correctional Service Act 8 of 1959, relating to his or her placement under community corrections, and is to be considered for such release and placement by the Correctional Supervision and Parole Board in terms of the policy and guidelines applied by the former parole boards prior to the commencement of these chapters. Honorable Chair, the Correctional Services Amendment Bill has therefore been developed to give effect to a Constitutional Court judgment and also amends the definition of minister by proposing to amend the following sections of the Correctional Services Act 1998, meaning the Principal Act. Section 1, the definition of minister. Section 73, subsection 6A, and 73, subsection 6B4, where the minimum detention period of sentenced offenders before becoming entitled to be considered for placement on parole for offences committed after the 1st of October 2004, and section 36, section 136, subsection 1, and 136, subsection 3A, the transitional provisions regarding placement on parole of sentence of offenders for offences committed before the 1st of October 2004. Honorable Chairperson, the committee received a briefing on the bill by the Department of Correctional Services on the 10th of May 2021, and thereafter the bill was published in national newspapers from the 29th of March 2021 with a deadline of 16th of April 2021. The bill was also published on the Parliament social media platforms and website from the 10th of March 2021. However, Honorable Chairperson, the committee received no public comments on the bill, and on the 19th of April 2021 proceeded to consider the Correctional Services Amendment Bill. The bill was unanimously supported by the committee without amendments. Honorable Chairperson, the Select Committee on Security and Justice, having considered the Correctional Services Amendment Bill B32/2020, referred to it and classified by the JTM as a Section 75 bill, submits the bill without proposed amendments for the Council's consideration. I thank you very much, Honorable Chairperson.
Thank you very much, Honorable Shaik. That concludes the debate. I now put the question, and the question is that the bill be agreed to. But before we proceed to voting, I shall now allow parties the opportunity to make their declarations of vote in terms of Rule 63, if they so wish, and maximum time allowed for this purpose is 3 minutes. So it's 3 minutes per declaration of vote. Any party wishing to make a declaration? Doesn't seem like there's any party wishing to make a declaration. Sorry? Yes, EFF, yeah.
Lekoko la EFF le emano ke molao yo mošwa yo itebagantseng le go fetola molao wa tsa magolegwa. Re emano ke molao yo ka go tlosa tsotlhe tse di neng di fitlhilwe mo molaong. Re dumela gore dipaakanyo tse di itebagantse sentle le katlholo ya ga phatlha e rotloeditseng molaotheo gore o sekasekiwe. Dintlha tsene di sa jese monate mo kgang ya katlholo ya phatlha di supile bokoa jo bo teng mo lenaneong la go itshwarela magolegwa. go lebeletswe ba ba atlholetsweng pele ga molao yo mošwa yo o tsenwa tirisong. The Act should stipulate that inmates who were sentenced after the commencement of the Act, which was on 1 October 2000, after serving a period of 25 years in jail. This introduced a new parole regime from October 2004 because before that, inmate would qualify for the parole after serving 20 years of imprisonment. This anomaly that means that if one was convicted before the 1st October 2004, but sentenced after the date, that person would be required to serve 25 years before qualifying for parole. As it happened to Patla, those amendments now make it clear that inmates must serve 25 years before they can be considered for parole if the offense was committed after the stroke 6 and 7 of the Correctional Service Act. On 1 October, when we support the bill, we are also aware that the Act may still be sustainable for more legal challenge in the future because there are still major gaps in the parole system. Example, the bill does not deal with the process of how inmates who qualify for parole are identified for the different categories of the offense. We suspend that this failure to be provided for a fairly reasonable process for the new parole regime will lead to the further abuse of the right of the inmate, being the beginning, not to be end of the thought-going process for the prisoners' reform. This must entirely a very clear process for the granting of parolees to all those who qualify, while ensuring that there are effective rehabilitation services. We do not need to make those amendments on a piecemeal basis as we are now, that there are reforms needed in the correctional service space. Apart from those valid concerns, we are in support of the bill. I thank you, Chair.
Thank you very much, Honorable Mzamai. We'll now move on to Honorable Nita from the ANC.
Thank you very much. Good morning to everyone. Chairperson, African National Congress rises to support the Bill 32 of 2020 and the report of the Select Committee. In 2015, the United Nations General Assembly adopted the revised United Nations Standard Minimum Rules for the treatment of prisoners and approved that they should be known as Nelson Mandela Rules in order to honor the legacy of former President Nelson Mandela, who spent 20 years in prison in a course of struggle and liberation. As we deliberate on this bill, we reflect on President Mandela's words, wherein he said, I quote, "It is said that no one truly knows a nation until one has been inside its jails. A nation should not be judged by how it treats its highest citizens, but its lowest ones." I close quote. Chairperson, under the Correctional Services Act of 1959, anyone sentenced to the life imprisonment was eligible to apply for a parole after serving a minimum of 20 years. In terms of the section of the Act of 1998, however, someone serving a life sentence is eligible for a parole only once they have served a minimum of 25 years. Section 1361 of the 1999 Act governs the transition from the parole eligibility requirements under the Section 159 Act to those under the 1999 Act. Section 139(1) provides that inmates sentenced before 1 October 2004 are subject to 1959 Act and must serve a minimum of 20 years. But inmates sentenced after 1st October 2004 are subject to the 1999 Act and must therefore serve a minimum of 25 years. In the matter of Pasha versus Minister of Justice of Correctional Services and others, Sakanyane intervention, the applicant, Mr. Pasha, is an inmate serving a sentence of life imprisonment. He was convicted for 25 of September 2004, a crime committed earlier, but was sentenced only for 5 October 2004. This means that he is required to serve 25 years before he may apply for a parole. Had Mr. Pasha had been sentenced a few days earlier, he would have had to serve only 20 years before being eligible for parole. Mr. Pasha challenged the sentence, the section 136(1) in the High Court on the grounds that the use of the date of sentence rather than the date of
move towards conclusion.
Oh, thank you very much, Chair. And the Constitutional Court ruled in favor of Mr. Pasha. We wanted to highlight that because it is the reason why we had to table the bill before the House so that we correct such. The African National Congress support the bill. Thank you, Chair.
Thank you very much. Any other party wishing to make a declaration? None. We will therefore proceed to voting on the question. I will allow 1 minute for delegates who are outside the virtual house to join the session. Yes. One minute. 30 seconds left. Fifteen seconds left. Thank you very much. Please note that each delegate, including special delegates, has one vote. The question is that the bill be agreed to. We will now move on to the voting. We'll start with those who are in favor. Can they please raise their hands and please keep those hands up. Those in favor, please raise your hands.
Thank you, Honorable Chairperson. Honorable Mushodi, vote in favor.
Vote.
Thank you, Chair.
Thank you, Chairperson. I vote on favor.
Somebody votes in favor, that's noted.
Honorable Chair, it's Sonia Bosov here. I can't seem to raise my hand, but I vote in favor. Thank you.
Please repeat that again.
It's Bosov speaking.
Bosov is voting in favor. Noted.
Chairperson, umkhiva ngapha. Nam ndivota in favor mntanomhle.
Thank you very much. That's noted.
And Mama Rehan in favor, Chairperson.
Marikhane's vote is noted.
Landsman in favor, Chairperson.
Landsman's vote is also noted.
Chairperson, Region Allen, Western Cape, also supported, unable to raise my hand. Thank you.
Again, is also voting in favor from the Western Cape.
Honorable Normanda Bloom from the Northern Cape also in favor.
Bloom also in favor.
Yes.
Honorable Masilela from Pumalanga vote in favor.
Let's start with Besa first, and then the vote from Pumalanga is from
Chair, Eastern Cape.
Eastern Cape. Besa, yes.
Yeah,
Noted.
agreed, yes. Agreeable, yes.
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 The another person who was speaking after Besa.
Honorable
Yes, what I'm saying, I'm saying we are
Masilela,
voting
Chair,
in favor.
from Pumalanga.
Let's note
In
you
favor,
one.
Chair.
Lindile, noted. Who's the other person?
Masilela Mpumalanga.
Masilela Mpumalanga, noted.
Masilela Mpumalanga.
Sigikolo, Mpumalanga, noted.
Sidikoloi, Chair for State.
Yes, noted. Oh, okay. Any other vote? Thank you very much. Now that the votes have been counted and the vote is complete for those in favor, we will ask the table to lower the hands. Thank you very much. We'll move on then to those who wish to register their vote against. Those against, please raise your hands.
All right.
Those outside the system, the hands are there, I can see them. Can the hands now be lowered so that we move on? Thank you very much. Can those who want to vote and indicate that they're abstaining, please raise their hands. Those abstaining, please raise your hands. It doesn't seem like there are any hands. Thank you very much. Voting is closed. We now await the results. The results are as follows. There's 58 hands who were voted in favor. Against 0, abstain 0. So the bill is agreed to in terms of Section 75 of the Constitution. Thank you very much.
Thank you.
Sure.
That concludes the business of the day. The House is now adjourned. Thank you.
Thank you.
Thank you,
Thank you,
Chair.
Chair.
Thank you. Thank you, Chairperson.
Happy birthday, Deputy.
Happy birthday, Deputy Chair.
Happy birthday, Deputy Chair.
Happy birthday, Deputy Chair.
Happy birthday, Deputy Chair. Where is the cake?
Malibongwe.
Where is the cake, Chair? Chair.
Deputy Chair.
Happy birthday.
Malibongwe. Enjoy your day,
Malibongwe.
Meruna. Kamala makosikazi.
On a Thursday, what a day.
Wow.
Deputy Chair, where is the cake?
Where's
Deputy
the
Chair, where
cake,
is the cake?
mommy?
Deputy Chair is in another meeting.
Oh. My other family, my people. That was quick, but.
Chair.
Are they? Yes, sir. Yeah, I can move some of the members.
Yeah, I can move them. Zama. Where?
Advocate, sorry, just
Yes, Advocate, we're busy moving people to the waiting room.
No, you had a full house.
yes, we did.
Yes.
It's Honorable Maida.